Komas, the Human Rights Popular Communications Center, handed a memorandum to the Human Rights Commission, Suhakam, over what they say is the persecution of Lena Hendry under the country's censorship law. Hendry works with Komas as its program coordinator. She was charged for screening a documentary on the Sri Lankan Civil War called No Fire Zone. Komas is requesting that Suhakam intervene to defend her rights and to check the unfettered powers of the Home Minister over film censorship. The Film Censorship Act 2002, they say, is wide-ranging and covers even home movies. Hendry is the first human rights activist to be charged under the Act. Those who had been previously charged had been illegal VCD peddlers. Representatives from several Rights NGOs, lawyers, and filmmakers accompanied Komas.
The Home Ministry and the Attorney General Chambers filed a charge against Ms. Lena Hendry on September 19, 2013 under the Film Censorship Act 2002 in connection with the screening of a video which was not vetted and approved by the Film Censorship Board of Malaysia. If convicted, she faces a sentence of, this is quoted from the law, a fine of not less than 5,000 ringgit and not more than 30,000 ringgit, or to imprisonment for a term not exceeding 3 years, or to both. She is charged under Section 6 of the Act that makes it an offence to, amongst others, to produce, manufacture, have in one's possession, circulate, distribute, and display such film or film publicity material which has not been approved by the board. Although 3 members of Komas were arrested the night of the screening, only Ms. Lena Hendry was charged almost 2 months later. Why is this a violation? And this is why we come to Suhakam, which is the human rights institution of Malaysia. The charging of Lena Hendry in September 2013 by the Malaysian government is seen as an effort to limit access to information and alternative views, particularly those highlighting human rights violation and alternative perspectives. This violates individual and public's right to information, freedom of expression and opinion. The act that she is charged under regulates all matter related to censorship of films. However, it carries such wide regulation or wide powers of regulation and makes all films illegal unless approved by the censorship board. The law does not have any written guidelines on which type of films are subjected to censorship. We therefore sincerely hope and seek Suhakam's consideration of this gross violation, human rights violation against an activist in Malaysia, and to intervene to defend her. We request Suhakam to use its powers and influence provided for by the law to write to the Attorney General to put an end to any act of harassment, including at the judicial level against Ms. Lena Hendry, as well as against all Komas members and all human rights defenders in Malaysia. We therefore seek that these charges be dropped.
My initial response is definitely we will bring this up to the chair and to the leadership of Suhakam. We will discuss this issue, especially when you've mentioned that it's from a human rights defender's point of view. Definitely, we will look into that aspect.
Section 6 of the Film Censorship Act is very widely worded. So it captures every film, all films which has not been approved by the board. And it doesn't even specify which films are that. Films which has violence, nudity, and such on, and so on and so forth. So our contention from the legal point of view, when we filed this striking out, we said that Section 6 is unconstitutional. Mainly because of 2 reasons. One, because it creates an unjustified prior restraint to the freedom of expression because of how Section 6 was worded. There is no exception, it just bans all film. The discretion to prosecute or to enforce the law lies on the enforcement agency and the prosecutor, the prosecution. So this is open for abuse. And number 2, our position is Section 6 is disproportionate to the aim and objective of the Act. Because if you read the Hansard, which the prosecutor relied on in their submissions to in the High Court, and the judge read it out, it was mainly to stifle pornography. But again, our position is if that is so, then you should provide it in the section as one of the exceptions. You can't just put a blanket ban on all types of film. So based on that, we say that Section 6 is unconstitutional.
I must mention here, and we're going to depart from the usual practice. When a particular matter is in court, we usually don't interfere. Right? But since this one is a matter of concern where a human rights defender is concerned, we will definitely refer this to the Commission, because it's the first time we're dealing with a human rights defender and a case that is in court.
But our worry is not the Sri Lankan movie per se, but all movies and all screenings, because all of us here defend many human rights issues in Malaysia, and we've been using films for a long time. I mean, Komas has a human rights film festival the last 10, 11 years. Other documentaries are also being screened by various NGOs now for education. Orang Asli videos, we use it for education. But this implication of this court case is very chilling, that they can now say that don't show anything, and I think some universities are also probably now asking the question whether they should show before an approval for educational purposes. There's no exception, as Joshua was saying. That's the problem. I'm not sure whether a wedding video needs permission or approval.
If you want to display it in public, even a wedding video, birthday celebration video, as long as it's unapproved by the censorship board, it's still an offence.
With us, only when we decide like a certain film, when we want to show it in a cinema, then we apply for the Cert A to get it.
What happens if it's a private screening?
So when let's say when I have a film that I don't think I want to release it to the public, I just do a private screening. Also, like in the same venue, we did many private screening before. We don't apply for cert. That's what we do before. So like this case of Lena actually deeply concerned us, the filmmaker community, because then we start to doubt, can we still continue to do what we do before, because we always screen films in certain venues, like in a health institute, in a university campus, or in the workshop, when it is like not for profit reason, we don't apply for the censorship board and we just show it to the public.
In my opinion, it would require some form of a roundtable discussion, because there's this long-fetching implications, far-fetched implications. Because what does it mean? Does it mean any other thing that comes out that has to be, and that becomes itself a issue of public interest, which has to be addressed. I'm of the opinion that we should invite two parties together from the KDN and perhaps other government agencies, as well as yourself, to a roundtable discussion, and you pose the question to them. We would be the sort of facilitators. What we would definitely do is this. The first thing is, we will address the questions to the Aegis chambers, and of course with a watching brief as well, holding a watching brief. The second one, of course, is we would need your assistance to help us, because to convey this to the commission, you won't be the commission meeting, and we need to convey this to them, to explain us. Frightfully is how you've told us, and fearfully, this has created a concern in us. So we need to do the same thing to them. And then moving on as to how best we're going to address this open-ended act so that others are protected. And this is where I think we would need to sit down and discuss what we're going to do. And we'd appreciate very much if you could guide us in that and help us.
I think we're very happy to work with Suhakam, because I think as a coalition of NGOs have come together to expose the arbitrariness and how wide-ranging powers are, unfettered powers on the minister. We want to show that this violates human rights. So we are already starting the discussion with some research. We already have some background research. The legal team has its arguments ready to help you in your case in the commission. So then we can prepare that for you as a backgrounder now, but as leading up to the round table, which I think is a brilliant idea, while the big plan of changing law, but the internal plan to have solid arguments as a guideline for legal people to do that. But I think the background, I think what Angela's point is very important, because we don't want to legitimize a bad law. Our goal is to strike down the bad law and make laws human rights compliant. I think that's the Suhakam role and our role together with you. And that's what we want to work together for that. But in the meanwhile, Lena Hendry's rights as an individual is being violated here. So the immediate concern is Lena Hendry. The bigger concern is the round table, which will definitely work with you. So I think we will be very happy to work with you, Mr. James.